Hello, my name is Robin Molyneux and I'm an immigration lawyer. Today I'm going to be talking about one of the most important cases of last year, the case of Zambrano, and the effect this decision by the European Court of Justice has on people who have British children but are themselves illegal in the UK. The background, briefly, is that Mr and Mrs Zambrano are both Colombian nationals who in the 1990s applied for asylum in Belgium. Their applications were refused, but they weren't removed to Colombia and they stayed in Belgium, making a number of further applications to try and regularise their immigration position. Though all the applications made by the Zambranos were unsuccessful and they did remain illegal, two of their children who were born in Belgium acquired Belgian citizenship. Mr Zambrano lost his job because he was illegal in Belgium, and when he tried to claim unemployment benefits, this was refused for the same reason. The matter before the European Court can be summed up in one sentence. Did Mr Zambrano have the right to live and work in Belgium to support his Belgian children? The European Court's judgment was that, as well as being Belgian nationals, the two Zambrano children are also European nationals, and the government of Belgium could not act in such a way as to deprive those children of their European citizenship. If the parent on whom the children were dependent was not given permission to live and work in Belgium, the children would be effectively deprived of their European citizenship, as without the means to support himself, the parent would have to leave the EU and the children would have to leave with him. The court therefore held that it was not legal for the Belgian authorities to permit Mr Zambrano to remain and support his children by working in Belgium. So, how does this judgment about two Belgian children with Colombian parents affect us here in the UK? Well, judgments of the European Court are binding on the UK, and the principle applies to any British child who faces having to leave the UK because their non-British parent, on whom the child is dependent, has no right to be in the UK. At the time of recording this, nearly 18 months after the judgment in the case of Ruiz Zambrano, the UK Border Agency has not yet published its final policy on how the UK will apply the Zambrano principle to the parents of British citizen children. In the meantime, however, they are accepting applications on this basis, and they will issue a certificate of application giving permission to work if an applicant can prove that he or she is the sole carer of a British child and can provide evidence of the relationship and the dependency. The UKBA have said that once the policy is finalised, people who meet the criteria will be allowed to remain in the UK. As this is a matter of European and not UK law, presumably after 5 years a person who's in the UK on this basis will be regarded as settled permanently. So if you think that you might be affected by the Zambrano judgment, don't delay. Call us now and speak to me or one of my colleagues to get help with lodging your application. Thanks very much for listening. I'll see you soon.